two very interesting discussions happened with two different associates who work with me on two different occasions, but they had very similar overlapping themes, and I thought I must talk about this. With both of these associates, one case where we have filed a suit for damages against the defendant, and with the other associate, I was discussing a civil suit for damages which was filed against us by the opposite plaintiff party. And both of these situations, where we are for the plaintiff and the other where we are for the defendant, we were discussing the fact that despite the fact that the defendant in both cases has clearly committed the wrongdoing which he or she has been accused of by the plaintiff, yet why is it that the defendant will go to court and contest this case? Why not just accept defeat? And I had to explain to these associates that this is a very similar mindset that I used to have back in the day when I had a few years of experience at the bar. I was very, very young. I used to think that if there is the law of the land, we apply it to the facts of the case, and whatever is the rational outcome, we go for it. And there is no point in fighting it out. But now, with a few more years of experience under the belt, I realize that your remedies in law, the facts applicable, are one different thing. But the process of justice, the justice system as it works, on a lot of occasions, defendants do not have the incentive to come clean and accept their mistake and to accept defeat. It makes far more sense, especially with good advocacy, good lawyering, that you can get away with a lot of wrongdoing in this country as well. Not that I condone it, but this is how things stand in this country. And what I mean by this is, in all of the civil suits that you will see transpire in front of you, you will always have, no matter how crystal clear things are, the requirement of the plaintiff to, by the process of law, prove every single thing that he needs to prove to come to a conclusion that what he is asking for is fair and just before the judge. And what happens is, there are a series of steps which the plaintiff needs to take in every different kind of civil suit which is there. And if there is any mistake on any step of the way among the hundreds of steps that are to be taken throughout the institution of the case, from the filing of the plaint to the ultimate final arguments, if any mistake happens on any step of the way, on a lot of occasions, the party, the client, will suffer the consequences of the plaintiff's lawyer's mistakes, and on a lot of occasions, the plaintiff's mistake as well. And that is why the defendants on a lot of occasions stand a good chance. If they put up a strong defense, even if they have no case, they might still succeed in denying the plaintiff any relief from the courts of law. And I say, especially in civil suits for damages, even after the plaintiff has proved its case in entirety, even then, the question of damages, what is the amount of damages which should be calculated to be awarded to the plaintiff and against the defendant, is another big thing. Say, for example, if millions and millions and millions of rupees or dollars is sought by the plaintiff proves their entire case as well. Despite that, the courts in India are very, very reluctant and are very shy in giving out large sums of money as demanded. There are many judgments of all the courts across India which say that you must prove actual damages, and actual loss on most days only should be given. So first you need to prove that actual loss, and then the courts are still very, very restrained in giving that to the plaintiff. And that is why, even if you have no excuse to contest a case, it still makes sense, sadly as the reality of this country is, to contest this case, because even at the end of the culmination of the proceedings, all things considered, you don't stand to lose much. And this is what something that you see when you deal with a good couple of hundred matters like this. The reality of the books, the concepts that are preached, are very, very different than what actually happens in a court of law. And the sooner you learn this, the better it is for you and your practice.